The left likes to pretend all their opponents believe in racial discrimination. That's not the case. That's a smear. In fact, they support systematically, in this case, admissions programs that racially discriminate on the basis of race. So another case that we're pursuing now is, or another case we're involved in now, is a case before the Supreme Court brought by Asian American students, an Asian American student group against Harvard that's over their race-based admission policies that discriminate against Asians. Essentially, Harvard's using race to punish Asian applicants and using race to benefit other racial categories. And it's illegal. It's unconstitutional. The Trump Justice Department was pursuing a case, but then the Biden administration came in, and because the left actually agrees with racial discrimination, they dropped the case. But the private plaintiffs are continuing the litigation, and Judicial Watch filed a brief in partnership with our friends at the Allied Educational Foundation with the Supreme Court, encouraging the court to take up the case. And I want to read a little bit from what we did here and to describe it, because, our lawyers spend a lot of time working on this material, and I don't want to give it short shrift by characterizing it in a way that doesn't give it its due, because it's great work and it highlights the key issues related to a race-based discrimination by the left. Now, you've been watching the news, I'm sure, and you've been seeing the latest left-wing news obsession with so-called anti-American, anti-Asian prejudice and harassment and violence, hate crimes, right? Well, the left doesn't care about that. I mean, they're just using it to advance their racially divisive agenda, which is designed to undo America, because they endorse discrimination based on race. Let me say it again. The left does not oppose discrimination based on race. They endorse discrimination based on race. So when they call you or anyone else a racist for opposing their agenda, just remember they support race-based decision-making by government. And we have filed this brief that I want to go through with you. It's the name of the case is Students for Fair Admission versus President and Fellows of Harvard College. Now, Students for Fair Admission argues that the admissions program intentionally discriminates, again, against Asian Americans on the basis of race and violates the Civil Rights Act, which bans unconstitutional race-based admissions by public universities. Pretty simple. Now, they also argue, this is where it gets into the law. I'm not a lawyer, I'll warn you, but generally speaking, there's been a series of cases by the Supreme Court which has been a kind of a semi-endorsement of these race-based admission policies. And accordingly, the petitioners say the Supreme Court should overrule the decision in Grutter versus Bollinger. So you can look that case up to find out what it's about, which held that the institutions of higher education could use race as a factor in admissions. That's right. The civil rights law bans discrimination based on race, but the Supreme Court, in an abuse of power, has decided it's okay. The petitioners allege that the discriminatory admissions policy violates the 14th Amendment's Equal Protection Clause. Now, you've heard the phrase Equal Protection Clause a lot. You probably haven't read the 14th Amendment recently. I'm going to read you what the Equal Protection Clause means. Again, think about this the next time you hear about diversity and quotas and equity, which is essentially quotas. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. That means you are protected under law from discrimination no matter what. And they can't introduce these categories of race when you tie it into the Civil Rights Act as a basis for discriminatory treatment. And we argued in our brief that, of course, the Equal Protection Clause is meant to stop this type of invidious discrimination. One of the core purposes of the Equal Protection Act Clause is to guarantee that individuals will be free from discrimination based upon race. It should come as no surprise to anyone that legalizing the use of race in deciding who is admitted to schools of higher learning has caused enormous conflict, including among members of the court. Meaning the court has been battling internally about allowing race to be used as a factor in college admissions programs. Now, of course, the left, what they say is that we need to have race as a factor because we, quote, need diversity. And it's essential to a learning environment in the public university system or elsewhere to have diversity. So diversity means we can discriminate based on race. College and university administrators might promote greater cross-racial understanding and tolerance in their students, not by racially discriminating against applicants for admission to their schools, but by working to make their schools more tolerant of the expression of different points of view. Admission programs that intentionally discriminate on the basis of race may themselves be negatively affecting the level of racial understanding and tolerance on today's college campuses, which is obviously completely at odds with the notion of diversity being a positive. You know, and the other big deal here is that, as I pointed out, I point out the judicial corruption in allowing this behavior to continue for decades. There were several cases in the past that allowed, despite the clear language of the 14th Amendment's Equal Protection Clause, race-based discrimination. You may have known, you remember Plessy versus Ferguson, Koremitsu, which was the case that allowed the internment of Japanese Americans based on race and ethnicity, etc. Rulings by this court, which held that under the Equal Protection Clause, individuals may be treated differently based on race, have been wrongfully decided. So we tell the court, fix it. Plessy versus Ferguson, the famous separate but equal case that upheld separate but equal based on race, on education. The court ruled that treating individuals based on racial classification did not violate the Equal Protection Clause. The court found that the government had justified its disparate treatment under the strict scrutiny test, which is such cases when such discriminatory conduct is uncovered, there has to be a strict scrutiny, meaning a very severe analysis, high bar to meet for the government to engage in that type of discrimination. Additionally, Judicial Watch argues that the case should be heard because the Supreme Court has failed to set clear precedent. They've been all over the map on this, on the issue of race-based discrimination programs. There's 43 years worth of cases that have failed to provide lower courts and university administrators about what constitutes a permissible race-based admissions program. This one key case called Bakke has led to 5 rulings over 43 years, 5 rulings over 43 years, in which there are 26 separate opinions. In each, the court attempts to explain the constitutional rationale for allowing race-based preferences, even though these plainly conflict with the original meaning and the text of the Equal Protection Clause. So I want you to go read the brief, and I want you to go read more about the case, so you are better equipped to deal with the radical left's dishonest attempts to use race to divide the country. They believe in racism. Constitutional conservatives, principled Americans, patriot Americans, they abhor the idea that some people get certain benefits based on their race. Not only do they think it goes against any notion of fairness or any notion of your even kind of your moral religious views, but it's illegal. The left likes to pretend all their opponents believe in racial discrimination. That's not the case. That's a smear. In fact, they support systematically, in this case, admissions programs that racially discriminate on the basis of race. I guess that's redundant. And as I say in my statement when we release this brief, court-sanctioned racial discrimination in college admissions is contrary to federal law and the U.S. Constitution. The Supreme Court should stop abusing its powers to protect racial discrimination and uphold the rights of Asian students and other innocents punished for being the wrong race by Harvard and other universities. Talking about elitism. They treat you differently according to your race in many colleges. It's outrageous. And I know this is just the tip of the iceberg, and the Supreme Court should step in and save the Constitution and protect the rights of Americans, or I guess further the Constitution from the assault that and the weakening it suffered by members of the court itself, and the organized left that has come up with this racial spoils system, which is an anathema to our constitutional republic.
Thanks for tuning in. Be sure to subscribe to our YouTube channel to catch all the latest news from Judicial Watch.